Support comes from St. Louis Public Library Foundation, helping the library serve children and their families with programs and services needed to become lifelong readers. More information about the foundation is at slpl.org.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. A federal judge in St. Louis is taking aggressive action against the local woman made famous or infamous by HBO's Chimp Crazy. Is there any way Tonia Haddix can now avoid criminal charges? A beloved local nonprofit says a for-profit company plans to use their name to sell alcohol without their consent. Do they have no recourse that wouldn't cost a six-figure sum? And lawyers fighting Abbott Laboratories won a big verdict in St. Louis a few months ago, only to see a jury stop them in their tracks more recently. Why do some would-be nuclear verdicts fizzle out? These big questions all involve high-profile cases in the St. Louis area's judicial system. And here today to help us make sense of them are three top local attorneys. Yes, today is our Legal Roundtable. And joining us now is Erin Lueker. She's an attorney at Sedey Harper Westhoff. She was previously a public defender for St. Louis County and a prosecuting attorney for the state of Missouri. Erin, welcome.
Thank you.
And we're also joined today by Javad Khazaeli. He's an attorney and founding member with the St. Louis firm Khazaeli Wersch. He's also a former federal prosecutor. Javad, welcome back.
Thanks for having me.
And last but not least, one of our Legal Roundtable's founding members. Mark Smith is a former associate vice chancellor and dean at Washington University. He taught law courses for 30 years, and he currently is teaching social studies at Narings Hall High School. Mark, welcome back.
Hey, thanks. Great to be here.
So we have so many exciting matters to talk about today. I think this is going to be a great show. I can't wait to talk more about Chimp Crazy. I've been obsessed with watching that docuseries. But before we get to that, there's a matter of public policy that we've talked about before on this show. It now has some potential resolution, and I want to get the take of the three attorneys who are here with us today. So when Missouri voters approved recreational cannabis, the new constitutional amendment that we all said yes to said that local government could levy a 3% tax increase on these purchases. That's on top of the normal sales tax. A host of municipalities did just that. But things got complicated in St. Louis County, St. Charles County as well. Those counties added their 3% in unincorporated areas, which the law clearly allowed them to do. But then they also tried to add their surcharge on top of the 3% charged by municipalities such as Florissant. In one instant, that led to a 20% sales tax when everything was all added together. So this Florissant dispensary sued. They lost in circuit court, but then in this past month, the appeals court had a much different take. Erin, what happened in this case?
Well, this is an interesting case where the difference of the interpretation of one single word can make the difference in millions of dollars for the county. As St. Louis County, St. Charles County are both involved in this lawsuit. The higher court actually reviewed the plain meaning rule, which was within the constitutional provision allowing these taxes, and found that these dual taxes could not occur at the same time. And so they dived deeply into the definition of what any means and what it means within this Constitution.
So the word that ended up being the key word was any?
Any and.
Any and and.
So it's exactly what lawyers love, and it's exactly what the population roll their eyes at when they're hearing about legal arguments, is the difference between any and. However, our higher courts reviewed it strictly within the context of this specific article. And what our lower courts had done was looked at the entire provision and the entire constitutional amendment and found it to mean something different.
What I thought was so ironic here, the judge who wrote on behalf of this three-judge appellate panel, this was Judge John Torbitsky, he wrote, "The plain language of the Constitution is unambiguous." I'm thinking, how can this be unambiguous if a lower court came to a completely different interpretation? Mark, just as Erin was saying here, this is kind of why some of us hate lawyers.
Right. Well, it's one of many reasons.
I won't list them all.
Yeah. The issue, it says local government means in the case of an incorporated area, a village, town, or city, and in this case, that would be Ferguson, because that was where it was happening.
Or Florissant.
Florissant, right. And in the case of an unincorporated area, a county. So the county was saying, well, you can do both. And interesting, the trial court said, well, if you take this interpretation that the appellate court came to, then that would mean that these marijuana dispensaries would not be subject to not just the tax, but also local rules having to do with safety and zoning. So they could be next to a school. And they said, well, that's clearly ridiculous. That's not what was intended. So we've got this case. We also have one, I think, down in Benton County or Buchanan County. Yeah. So I think we're going to see this bubbling up. I would imagine the Missouri Supreme Court is eventually going to have to interpret this language to decide.
Well, yeah. So now St. Louis County, St. Charles County, they're saying they're going to appeal. Yeah. Javad, do you think that the Supreme Court could find a way to rule differently than what the appellate court did here?
I think they could. I mean, my first reading of this, when I see any, that means everybody. That doesn't mean a. They also said that later on in that same clause, they used the term such political subdivision. And because division is singular, everybody would realize this. But I think
this doesn't just come down to one word, it comes down to one letter?
I think it could. If this had said such political subdivisions, then it could be. But overall, this is a different conversation. We just had a bunch of amendments up for vote about the casino and about sports betting. And when sports betting was pushed, the biggest ad campaign that we saw was, you need to have sports betting because this money is going to fix our schools. We had that same argument with the lottery. And what we've seen routinely in Missouri is we push these things that say this is going to be good for the taxpayer. And then as soon as it's implemented and the dispensaries are there, there's going to be a fight to cut down the tax liability. And when you see some of the exit polling on why people were voting against sports betting, it wasn't necessarily because they were against it. It's because they saw that the argument of this is going to help the schools was so insincere. Mm-hmm. If they just come out and said, you know what, people should have the right to do what they want with their money, I think it would have been a blowout. Now I think the vote's down to like a 300 vote difference on that during the recounts. So this idea that we need to be doing things because it's going to be better for the taxpayers, people just are smart enough to realize then we're just going to fight that left and right.
Yeah, it doesn't seem to be how it works over time. Erin?
Well, one interesting aspect that the courts are taking into consideration is the actual intent of the voters in enacting these taxes. So typically when we look at a law and we look at statutory interpretation of that law, we look at the legislative intent and we look and see what the arguments were made and what the votes were like in Congress. In this case, we have a constitutional amendment. And so it's really about interpreting what the voters wanted. And there's much less transcripts and dialogue with that. And we have to look at common sense. We have to look at what we anticipated, what people were promised. But at the end of the day, it's a little bit of a guesswork.
Yeah, it certainly seems like guesswork and that a lot of voters were just coming in going, yay, recreational marijuana. Like, I don't think some of us thought through more details than that.
Well, what I was going to say, and now I'm taking off my lawyer hat and putting on my new social studies teacher, high school social studies. But, you know, in the United States, we live in a republic, which means we elect representatives to pass the laws for us. We don't vote on the laws. And we have this initiative, referendum, kind of for when the legislature is not doing what we want. But we're not supposed to be using it all the time because it's not a good way to make laws. And because voters don't always know what they're voting on. And so this is kind of an example of that we go to the polls, and like I said, sometimes you have to have these because the legislature is going contrary to the will of the voters, but it's not the best way to make laws.
Yeah. And it sounds like it makes it harder then for the courts to figure out what to do here. This is just kind of a complication as it's asking those questions.
Well, and I think we had a lot of really important amendments on the ballot this year. I think the voice of Missouri was heard loud and clear on a lot of really important issues. And I think it is a way for the people to take back some of the power that's been deferred to the government. And so I think this back and forth between what words mean, what letters measures mean is appropriate for a higher court to decide, and will hopefully do so with all the basic principles that we have. But I would strongly encourage to still have these types of measures on a ballot for the people.
Yeah, I don't think,
Yeah, I agree with you on that.
So as you're listening to our discussion amongst our esteemed panelists here, you may have a question or comment. You may wonder what the definition of is. Well, we have just the panel to try to answer that for you. You can call us at 314-382-8255. That's 382-TALK. You can also send us a tweet at STL on air, and you can join that conversation. So there's another case that was in the news this past month. A mother and daughter visiting from Chicago for a Drake concert in February were killed by an out-of-control driver. They're now suing the driver and his mother, but not suing the city. Now, that's different than what we saw in the case of Janae Edmondson. She, of course, is the visiting volleyball player who had to have both of her legs amputated after being hit by a St. Louis driver. Javad, what do you think is the thinking on having a different legal strategy in what seems like, on their face, somewhat similar sets of facts here?
Well, remember, both of these cases are very early into the litigation. So whether the city eventually gets kicked out of the Edmondson case or whether the city gets brought into the other case is yet to be determined. The way that the city was kept into the Edmondson case, it was based on an argument regarding sovereign immunity. And because of all the police cases we do, we're really deep into this argument with the city. I think most taxpayers would be shocked to learn that the city of St. Louis now claims, even though for years they claim that they have insurance, now they claim that they're not insured anymore. They have no basis for insurance. They actually had something called the PFPC, the Public Facilities Private Corporation, that was in charge of that. They dissolved that. So there's no insurance, even though the city has gone to the taxpayers, not the taxpayers, their bondholders, and claimed that they have insurance. And the reason that they did that is one of the ways to get out from under sovereign immunity is to claim that you don't have insurance. By having insurance, you waive the argument for sovereign immunity. But there's another way to get around sovereign immunity, and that's to claim that you have done something that has caused dangerous property. And that's what it's called a dangerous condition exception. And that's what the Edmondsons have argued. Now, we're at the beginning stages. So literally all they've done is put one line in their petition that says there are dangerous conditions here. Whether evidence will come up that shows that the city also has to know that that dangerous condition existed. Whether there will be enough of that when we get down to summary judgment, I don't know. There's a lot of information that intersection was known to be problematic. If the other family from Chicago learns that same type of stuff, they can add that in later. I don't know what their reasoning is on this. It's a harder argument. But
harder to make the case against a municipality as
Correct.
Opposed to the driver of the car.
Correct. Except for I live in the city. You know, our streets are terrible.
Right.
I blow out a tire basically once every 8 months on a pothole. I see people drive through these intersections. We see that we don't have traffic police around there. Everybody knows, every time I drive in another city, people honk at me when the light turns green because I don't go, because you've got to do the St. Louis 3-second wait to see if somebody's running that red light, and there's nobody there to stop them. So we all know that our streets are chaos here. I think this morning I saw somebody post that's like Grand Theft Auto out there.
Yeah, it often does feel like that. I'm wondering if, as they make the case of dangerous conditions, try to implicate the city in this lawsuit, can that be about, wow, we have a lot of bad drivers that we don't hold to account, or is that more just about road design? Erin?
No. So it's those intervening actors. And so that's going to be an important part of the analysis and whether or not immunity applies. So in the Edmondson case, they did sue and allege that the city owned and controlled these roadways. So they had a duty and obligation to have proper signage, proper sight lines, and this, designs were up to standard and to code. They can't then allege that these independent actors who run through stop signs, who run through the stoplights, as they did in this most recent incident where they blew through a red light, is something that the city can be held accountable for. Similarly, when we look at police chases, and this is when immunity is most often described and discussed, at least in Missouri, when police run through red lights, but they're in pursuit of another actor who is acting independent of a government agency, do we then hold the police accountable if they hit a car when they're running through a red light? And in the most recent years, 3, 4, 5 years, our Missouri's courts have really chipped away at the liability on police officers when they're acting in their own capacity and their official duties. We are seeing much less of that balance that we look for with immunity, where we can hold the public officials accountable for the decisions they make versus giving them the ability to perform and act in concert with the circumstances.
And you're saying that in recent years, we're moving into a direction of giving them more latitude?
Much more latitude. It is extremely hard right now to go against a state actor or a government actor, a police entity, in a civil lawsuit involving actions that were directly as a result of their what they were performing on behalf of the government.
So, Javad, that actually brings us to a case that you handled in this last month. This is one that was a very high-profile case. I feel like I've been talking about the Isaiah Hammett case since 2017 when this happened. It, got a lot of people's attention. It was just the SWAT team raided this house and a young man ended up dead. This one ended up resulting in a jury not finding these SWAT team members liable.
Yeah, so our law firm co-counseled this with the St. Louis University Law Clinic. What is tragic about this case is that there was a warrant to go and arrest Mr. Hammett. And that warrant was very specific, that it was supposed to be a knock warrant. And the officers on the scene changed their mind.
And the knock warrant, they're announcing, police, come let us in, not just charging in.
And what was alleged in this case is that they did instead change their mind, charge in, and more than that, throw a flashbang grenade that went off and to disorient people. Now, there was no question that Mr. Hammett, in his response to that, not knowing who was in his house, fired a weapon in defense. The question came down to what happened about a minute and a half later when he came out of a room. His grandfather, who was a disabled vet, testified that he asked Isaiah, "Do you know who's here?" No. Isaiah didn't have a gun at the time, goes out the door, and is shot dozens of times by the police. But he is found with a gun next to him. Even though he's riddled with bullets, the gun has no DNA on it of his, no blood on it. Goes to a jury. The jury determined that he did have the gun. So this was one question. It's a difficult case, though. I mean, all of these cases are difficult. Once you have somebody shooting a weapon, even if the police aren't there, as Erin said, there's a lot of deference given. At the same time, when there are these types of allegations, it's our job to keep pushing for the truth. Had attorneys not been involved in this, nobody would have ever learned the question about the DNA, the question of the bullets. And ultimately, juries are fickle. One jury could think one thing, another jury could get the same facts and rule totally different. That even happens in our federal courts. We take, as Erin was saying, we'll take cases to the 8th Circuit here on a police brutality case, and we'll lose on qualified immunity. That exact same case across the river in the 7th Circuit, the law is totally different. We could win that. So there's a bit of arbitrariness to this.
I don't want to keep banging this drum of how much I hate lawyers, because I do love lawyers. Like, you guys are my favorite people to have come in and talk to us and share with us. But Mark, that arbitrariness sometimes seems to offend the conscience of people from the outside looking in.
Yeah, I mean, it's, what Javad is talking about, this split, that different circuits, in the United States, obviously the Supreme Court makes the law, interprets federal law for the whole country, and then we have 12 or 13 circuits, I think 13, right? And I should know that. And they then interpret the law, and they'll sometimes they have to be consistent with the Supreme Court, but the 7th Circuit, which is Illinois, might be a little different than the 8th Circuit, and you get these differences. And some courts are more conservative, some are more liberal, and it does But usually over time it gets worked out and we have a consistent. But yeah, we're going to have some differences sometimes.
And I do have to take a break here, but Erin, I'm going to let you share one last thought before we do that.
It's actually the beauty of the justice system because we have juries making fact-based analysis off of independent cases, and what they do is they apply that to the law. So while it may seem arbitrary, it's very fact-specific, which means everybody gets their day in court.
We are talking today to our Legal Roundtable. That's Erin Lueker. We're also joined by Mark Smith and Javad Khazaeli. When we come back, we'll discuss a trademark dispute involving a beloved local nonprofit. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky. I'm in for Elaine Cha today because today is our monthly Legal Roundtable. You can always catch us in sort of that final week of the month as we convene 3 top lawyers to talk about all the interesting matters happening involving our judicial system. Today, that includes Mark Smith, a former associate vice chancellor and dean at Washington University. He currently teaches social studies at Narings Hall High School. We're also joined by Erin Lueker, who's at Sede Harper Westhoff, previously a public defender for St. Louis County and a prosecuting attorney for the state of Missouri. And we're also joined by Javad Khazaeli, who's a founding member of the St. Louis firm Khazaeli Wersch and a former federal prosecutor. So a much-loved St. Louis nonprofit was in the news this past month. The club of soccer supporters called the St. Louligans said that an unnamed company had sought to trademark their name without their consent. And it turns out this company is looking to sell a beverage, including probably alcoholic beverages, under the name Louligan. Now, the Louligans had previously successfully trademarked their logo, but they decided they couldn't fight this beverage company that wanted to trademark their own name. We started looking at it, one of the founders told me, and the legal cost to battle this would probably end up in the range of a used to new Honda Accord. And if this third party has enough money for a registrar and a flavor developer, they probably have enough money to drag this out and bleed us dry. Javad, do you think he's reading that situation accurately?
Yeah. I mean, the legal system is expensive. It takes a lot of effort, and especially when you're going up against somebody who has more resources than you. Why I think this case has kind of resonated with everybody, though, is, as you said, the Louligans are much beloved. I remember when they were out at the St. Louis soccer park going to watch St. Louis FC. I was there. I had one of their banners. I've got season tickets. And having the Louligans cheering is one of the things that makes the stadium great. But the part that really kind of bothers me is that Louligan is a made-up word. This isn't like last month when I was on, when we were talking about Mission Taco and the Mission Tortilla. Everybody uses the word Louligan. I mean, doesn't use the word Louligan. They use the word mission. And the fact that Louligan is only associated with this group and somebody else is taking it, and even if they're not going to stop the Louligans from using it, the fact that they're making money off the back of the Louligans, I would imagine I'm their target audience, you know.
Buy this Louligan beer.
Yeah, I'm not going to.
Yeah.
You know,
now you won't.
I won't. No,
Yeah.
I won't, you know, because I know that you're on the backs of these guys and you're doing something that isn't right. If somebody had approached them and said, hey, let's partner up, which there have been partnered Louligan beers before, we would all be on board. So it's just one of these things that, yes, there's a system that you can come to a response. It's long. It's, you know, I get the calls from about my Bar PM case. We're coming up on a year. I still haven't done a deposition yet. These things take forever to go. And it just feels fundamentally unfair that you can take something I made, put your stamp on it, and then sell it.
Yeah, and Mark, is this potentially going to be a problem for them that, again, they have this made-up name that they made up. Yeah. Somebody else is trademarking that name. Could they run into problems using their own name?
I don't think they could. I mean, anything's possible, and they could try and the beverage manufacturer could try and do some kind of infringement action against them. But I mean, they're not making their beverages; they're doing these charitable events. So I think they would, and I don't think this would be a tarnishment type case. Yeah. So I think they'd probably be okay. But like I said, if they wanted to be really difficult, the beverage place, they could and this is kind of what Javad's saying. Even if you don't win, the legal system can just tie you up, so you can't do what you want to do because it's too hard and too expensive to fight the procedures and everything. And the only time you get a free attorney is if you're charged with a crime. You don't get it for other stuff.
Yeah, civil suits. It's very rare to have an attorney working for free on. Erin, the St. Louligans went public about this because I think they thought, well, we can't fight this legally. We can fight this maybe in the court of public opinion to get somebody like Javad to say, well, I'm not going to drink that beer. I don't care that I love the St. Louligans. I don't like this beer. Is that really, this is kind of the recourse they have, unless they want to spend that Honda Accord money?
Well, I'm not sure that there is a conflict right now for them to even bring to a court system. So the trademark that's been applied for is within a specific class of goods and services. So when you apply for a trademark, you have to designate exactly what it's going to be used for. In this case, a beverage. And so with the Louligans, there is no conflict necessarily because they weren't going to manufacture a beverage and then put the Louligans term on it. And so this is, perhaps an early recourse to demand the court of public opinion, which can be very powerful as well. However, I don't necessarily see that this is a David and Goliath situation, given that they're being used for two completely different things. And words do have power. Words do have meaning. Even words with an S or not an S on it. But Stephen Colbert used the term truthiness several years ago, and that made its way in the way to a dictionary and to other types of proceedings. And similar, Louligans has been created and has its own mind at this point. It's within everybody in St. Louis and used in many different ways, not just with this nonprofit and not just with the beverage company.
Erin is our dose of optimism on the show
really.
today. I'm impressed. Javad, you're more of our pessimist here, and I see your brow is furrowed.
So I just did a search on my computer for St. Louligans and beer, and I see a picture on their Instagram page where they did a co-branded beer called Louligans with a brewery. They do all of their events at Schlafly. Drinking is something that is very wrapped into the soccer sports thing dynamic. And the idea that somebody can come in, put a label on this, and then in the future, these guys are probably going to have to forego doing co-branding, doing events that are beer-related around this. There are other sports soccer supporting groups throughout the world that do their own beers. Now, if this goes through, they will probably not be able to. And the fact that they're using a name that the Louligans came up with just seems fundamentally wrong to me. So I'm glad that when you pointed at me, you didn't say, Javad, you should take this case for free because I don't do this. But I would love to see somebody come up and do this and defend
Take this on pro bono.
Take this on pro bono and come up and at least force some kind of agreement that says the Louligans will never be barred from using their own name. If somebody came out with Javad Khazaeli beer, which would be awesome, first of all. It would be full-bodied and delicious. That I would fight that.
You would fight that. You'd fight pro bono for yourself, but not for the Louligans.
True.
Yeah.
Yes.
Well, hopefully someone more generously minded is no, Javad, I'm joking. But yeah, this would be a good thing for somebody to want to do pro bono. I know some of these big firms, they like to take on cases. This could give them kind of like a nice media buzz. We'd all cover this. I don't know. Mark, you think somebody could,
they might.
could pick this up?
And it's a very specialized area of the law, so
That's
you would
a good
need
point.
people who know something about it. Right?
So that's why Javad can't do it. I understand.
Exactly.
Yeah. Okay, changing gears here. So a battle is brewing over a big question. Who gets to appoint the successor for St. Louis County prosecuting attorney Wesley Bell? He is, of course, headed to Congress. He'll be there in January. We need a prosecuting attorney. The question is who gets to choose who it is? County Executive Sam Page says it's him. Attorney General Andrew Bailey has said that it's Governor Mike Parson. Mark, what does the law tell us?
So if you look at it, it's at Article 4, Section 4, says the governor shall fill all vacancies unless otherwise provided by law. And that's what Andrew Bailey is hanging his hat on. And then the county councilor, Dana Redwing, did a nice letter to Bailey because Bailey said, hey, this is our view. You got to let us know if you don't agree. And she says that Article 6, Section 18A and B says that St. Louis County must provide for a manner of selection for the prosecuting attorney. So she's saying, look, the Constitution says we have to provide for a manner, so that's controlling. That's the unless otherwise provided by law. So I don't know. This is not my area of expertise, and I haven't looked at the rest of it, but it seemed to me like she had a relatively convincing argument. I think also you've got the fact that when St. Charles did it, it came up. The governor's office didn't assert the right. They did do it with St. Louis City, but if you read her letter, she says St. Louis City's different because it specifically says they're not to appoint
and it
a
is
replacement.
A different position. Here we have a circuit attorney that does that same prosecutorial
We're
function.
the weird city in it.
We're the only one in the state that has a circuit attorney. Yeah, so it's handled a little bit differently. Erin, what do you make of this legal battle? Do you think that the Dana Red Wing, representing Sam Page, made an argument that is going to end up holding sway?
Well, I certainly think the underlying concern that people have, I think the office might have, I think that the county has, is the influence of politics and power influencing the decision, the very important decision on who to appoint next. Certainly, Wesley Bell came into an office. It was an extremely contentious, hard-fought election, if you remember, and the circumstances leading up to it. And he implemented several changes into the office, arguably, and in my opinion, very favorable changes that benefited the citizens of St. Louis County. And so the concern, of course, being we have a very conservative government in power. We have a governor who's a Republican. Wesley Bell was a Democrat. The vast majority of St. Louis County voted in democratically in this last election. And so if we have an appointing power by the governor, bringing in somebody, an outsider, if you will, which I'm not sure who the applicants are, that's going to change the will of what the people who elected Wesley Bell wanted, which was to have somebody more liberal, more democratic, implementing the criminal code.
Javon.
And I think that's a very important point that is not a part of this conversation. Did Wesley Bell know when he ran for Congress that there was a chance that we could get a far right-wing prosecutor in? Wesley Bell ran and said, I'm basically going to vote the exact same way as Cori Bush on so many things. And one big thing that he made a big point of was women's rights when it comes to women's health care. Now we could get a prosecutor who could come in and be against women's rights. Was this something that Wesley Bell knew was a possibility? And didn't he kind of have an obligation to tell people when he ran that if you elect me, we might end up with an Andrew Bailey clone? I don't know why we're having this conversation. We're not talking about what put us in this position.
Well, I will say, in fairness to Wesley Bell, at the time that he was running, reporters made inquiries, what will happen if this seat is vacated? And what we were told is County Executive Sam Page's office told us, this is 100% our appointee. And they said, look at what happened with Steve Ellman in St. Charles County. There's this very recent precedent here. They wouldn't dare. Now, obviously, we know that they've dared. Let's say they go ahead and try to make an appointment. What's the legal move here? Does the county come in and, I don't know, try to get a temporary restraining order, stop this whole process? I don't know.
And just to be clear, it's not Bailey that's going to make the appointment. Parson's saying it would be him. And you know, I may disagree with Governor Parson on a lot of issues, but I think he's done a relatively good job with at least local judges and tried to bring some diversity in.
He appointed Circuit Attorney Gabe Gore, who is doing a fantastic job.
Extraordinary job, right.
Except for on the Bar PM case.
Except for that case, a great point.
Except for on the Bar PM case. Feel free to write him about that.
Yeah.
That was a joke.
Well, maybe somebody out there will want to write him a letter. Erin, I saw you wanting to jump in.
Certainly. My primary concern is, of course, when we have these political battles or power struggles is what's going to happen to the actual office. Because what we have are everyday prosecutors, everyday law enforcement officers, people who need this system to work smoothly and effectively without large drastic changes. And in worst case scenario, we have two separate individuals appointed to this position. What happens is a lot of chaos and insecurity. And what we need is faith in the criminal justice system. What we need is that faith that everyday problems that our people face are going to be addressed, and they're going to be addressed quickly. And we want to know how they're going to be addressed, most importantly.
I'm going to give you the last word here.
And the other portion is the names that you're hearing out of Sam Page's office aren't radicals. I mean, the main name that you're hearing out there is a person who's a career prosecutor, was in the city, is universally respected in the criminal defense and prosecution world, and somebody who has been involved in what's happening in St. Louis County and can be plug and play, ready to go. So it's not like we're looking at somebody who's unqualified or some kind of political hack. This is somebody who, when you talk about best choices, she's right up there.
We're talking today to our Legal Roundtable. That's Javad Khazaeli. We're also joined by Erin Lueker and Mark Smith. We're going to take a quick break. When we come back, will criminal charges result from Chimp Crazy? Oh, I can't wait to talk about this one. This is St. Louis on the Air on St. Louis Public Radio. Welcome back. I'm Sarah Fensky. Today, this is our Legal Roundtable. I am joined by Javad Khazaeli, who's with the St. Louis firm Khazaeli Wersch. Also joined by Mark Smith, a longtime attorney who's taught law classes and now teaches social studies. Also joined by Erin Lueker of Sedey Harper Westoff, previously both a public defender and a prosecuting attorney. So, getting right to the case that I've been waiting to talk about all day, and that involves Tonia Haddix, the former St. Louis nurse who gained national infamy due to HBO's Chimp Crazy docuseries. And as I was just telling Mark in the break, it's actually a very good piece of art. People should watch this. This docuseries, though, showed Tonia Haddix lying at a court hearing to U.S. District Court Judge Catherine Perry. And what's extremely ill-advised is then she just kind of casually admitted to the deceit while the cameras were rolling. Now, even before Perry knew about that direct admission, she'd made a referral to the U.S. Attorney's Office to see if federal prosecutors would bring a perjury case. So far, they haven't done so. On Friday, Judge Perry ordered the U.S. Attorney's Office to make a charging decision by December 16th, or she said she's going to take some steps. And we'll talk about what those steps are. But Erin, I found myself wondering, can a judge just do that? Can they order the U.S. Attorney's Office, here is your deadline?
Absolutely. So the rule of the Federal Rule of Criminal Procedure, Rule 42, if you want to look it up and fact check me, prescribes the exact procedure for criminal contempt in a federal court. That includes laying out the facts, essential facts for the purposes of the criminal contempt, and it includes referring the case to the U.S. Attorney's Office. It also prescribes a remedy for if the U.S. Attorney's Office declines the case. It, in fact, instructs the court that they must then appoint a separate attorney in order to prosecute the case.
So PETA issued a press release on this. They're the ones who've been battling Tonia Haddix now going back to like 2017. They said the series of steps that she's taken, where she said she'll appoint this private attorney if the U.S. Attorney's Office isn't going to bring criminal charges. They say this means she's, quote, guaranteed to face federal criminal charges. I found myself wondering about that word guaranteed. Like, would this private attorney that she appoints, would they have prosecutor's discretion? Is that spelled out, Erin, in anything you've read?
It isn't spelled out. However, it is I think, implied within these rules that these are acts that occurred directly in court. And so the concern is, of course, with civil contempt or criminal contempt that occurs in a court is you have a judge who's the witness to it. And so what we want to do is avoid, of course, any idea of malicious prosecution by a court. However, the evidence there is much more clear and succinct than it would be in other types of criminal proceedings where you would need more prosecutorial discretion. The facts themselves are often going to be recorded and documented as part of the court record. And so whether or not there's going to be prosecutorial discretion after somebody is appointed, if they are in fact appointed, I'm not sure. But it's also unclear if they need that additional discretion.
So, Javad, I have to turn to you because I consider you our resident expert in chimp law.
This is the second time we've talked about this. There's no Nelly involved in this one, but yeah, I don't know whether it's guaranteed generally.
Sure.
But this is an 11-page order that lays this out in detail, including the judge telling her that even though you're doing this via Zoom, you cannot record this. And she says, I'm not recording this. And then there's a camera crew behind her. And then there's on TV where the camera crew records her saying, I just lied to the judge. I have like two things that keep just jumping into my mind every time I read this. There's an episode of The Wire where all the drug dealers are getting together and one guy starts taking notes and the guy's like, are you taking notes on a criminal conspiracy? And then there was a viral video last year of a guy doing traffic court on Zoom and his ticket was for driving without a license. And while he was on the Zoom, he was driving his car. And the judge was like, are you driving now? And those cases, I think, are harder than this case. I mean, it's not just that she lied repeatedly to the judge. Mm-hmm. She then went and admitted the lie, bragged about the lie on a TV show that's seen around the world, and lots of people, including you, are obsessed with this. And then she tried to market it. She went out and tried to get more people to watch the show because she's so audacious that she's willing to lie to a judge and nothing will ever happen to you. And the moment you tell a federal judge, especially one who is universally respected like Catherine Perry, that there's nothing you can do to me. You know, I remember being a little kid and telling my parents, there's nothing you can do. And that's when they did something real bad.
I can't even blame your parents at that
and
point.
With what Javad's saying about Judge Perry, I mean, she is an extremely solid judge, really smart, and with a very small ego. This is not about her. She seems like she's been, in this case, beyond patient. And so, but she's not going to let somebody make a mockery of our federal court system, and nor should she. And so I think she has no choice but to do what she's doing. I think, like I said, she's been beyond patient. But these people who just flout the legal system with like, what are you going to do to me? Eventually something has to happen. And this seems like such a good fact pattern for this woman to be held criminally in contempt.
It just seems so clear-cut. I should mention, Tonia Haddix, we also interviewed her on this show back when I was the host of it, and she flat out lied to me. She was sobbing about how sad she was about the death of a chimpanzee that we now know was alive. And obviously, you can lie to journalists. Everybody lies to journalists. But you can't do that to a federal judge.
The power of public radio on her. That'll be worse than anything the federal court could do. Yeah.
She will not get a free tote bag this year.
Yeah, no,
that's right. That'll teach her.
Make her listen to pledge drives all the time or something.
People are now biting the hand that's feeding them, let me tell you.
I shouldn't have said that.
All right. Well, we also discussed on this show a few months ago a, quote, nuclear verdict that Abbott Laboratories had lost in a St. Louis City Circuit Court. That was a $495 million verdict against the manufacturer of infant formula. A mother had sued, saying her premature infant had developed necrotizing enterocolitis, better known as NEC, after being fed the cow's milk formula at Cardinal Glennon. Well, last month, a Creve Coeur women's case against the same manufacturer went to trial. This was also in St. Louis City. Fun fact, it was the very same judge. This was Judge Mike Noble. This woman said that her premature infant had also developed NEC after being given cow's milk formula, in this case at St. Louis Children's Hospital. This jury returned a verdict of $0. So in one case, with a pretty similar fact pattern, we're talking $495 million verdict. And in the other, we're talking $0. Mark, it kind of floors me.
Well, and this is one of the bad things of our justice system is that you do get these different results. Now, granted, the facts, as Erin pointed out, facts could be very different, and maybe in one case. But, a person with a more cynical view might say, well, you have a jury that maybe is not the most sophisticated, listening to very complicated explanation of how medical conditions come about, and sometimes they come to a decision and it may not be the most logical one. Having said that, this is part of the reason big companies will often settle in these cases, not because they think they did anything bad. And now I'm talking as a former defense lawyer for big corporations. You just don't want to bet the whole corporation on the fact that these 12 citizens will get what you think is the right outcome. And so people will sometimes settle just to say, I can't take this risk. Even if it's 10%, that's too big of risk.
Yeah, I can understand that. I mean, the stock on this company, it went way down after this first one. Now it came back up after this second one. Like, there are jobs at stake. Erin?
Well, I do think we need to emphasize the fact-based nature of the evaluation both juries handled in these cases. So in the first case, we had an infant who was in NICU but was doing well, trending upward, and was medically stable before she received the formula and became sick. In this most recent case, we had an infant who was weighing barely 2.2 pounds, was so premature, had a lot of compounding issues in addition to the NEC. And so the argument made by defense was that the NEC was more likely to occur on its own anyway. And so drawing the correlation between consumption of the formula and his subsequent infection was much more difficult for the plaintiffs than it was in the first case. So again, we go back to trusting juries to accept and understand the information and apply it to those facts of the case. With that being said, defense companies learn what these cases are like and what juries are like. They certainly had an opportunity to learn from their first case and from their first mistakes. There are over 1,000 of these lawsuits across the United States, and they may be more bold now to start trying more of these cases, knowing that there may be good arguments out there that juries are willing to understand and to implement.
Yeah, I mean, this first one in St. Louis, this was sort of this bellwether case. I do want to mention the company has made a statement saying there's no scientific evidence showing that their preterm infant products cause or contribute to causing NEC. And what's interesting is U.S. regulatory agencies, a working group of scientists convened by the National Institutes of Health, they ended up concluding that current evidence doesn't support the hypothesis that the formula causes this particular disease and NEC. What's interesting is they came out with this finding sort of midway through this second trial. They were not allowed to use it. Judge Noble left it out, and they still ended up winning. Javon?
As opposed to Mark, I have made a career of representing the people. And I'm not worried about...
Corporations are people too, Javon.
Right. I've got to be really careful with Mark because he teaches at my daughter's school, and I want to make sure that there's no negative outcomes for her. I think Erin said it right. I don't see these as being radically bad decisions if the facts that she laid out are true.
Yeah.
From a surface level, this may look like inconsistent decisions, but with some of the stuff that Erin talked about, maybe they aren't. We're at a sample set of 2. There are thousands of these cases. What we'll see over the next 4, 5, 6 cases is more of a pattern. Once you see that pattern, that's going to make both sides be able to realize, can we do a mass settlement on these? But just remember, when the tobacco companies were sued, for decades they won. For decades, they won over and over and over again. And for decades, the regulatory people were like, cigarette smoking isn't bad for you. Then the science caught up to it, and everything switched. So these cases, a lot of times we've learned more. I will tell you, I doubt that the regulatory people would have looked at this closely if it wasn't for these 1,000 cases that are out there. Good decisions will come from this. We're going to see what the next 4 or 5 cases are. From a plaintiff's attorney's point of view, I would just say these guys have done 2 cases and they're averaging $245 million per case. That's a pretty good day.
Pretty good day, apparently. But again, some really sad cases. And I'm grateful that we can dig into some of these facts because, as you say, it all comes down to the fact pattern. One reason I love talking to this legal roundtable. Javad Khazaeli of Khazaeli Wersch, thanks so much for joining us today.
Thanks for having me.
And Erin Lueker of Sadeh Harper Westhoff, thank you.
Thank you.
And Mark Smith, thanks so much.
Always a pleasure.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.